Hi, I'm Angela Princeville,
I'm Shireen Abdi.
and today we are going to be giving you a court tip, and we're going to call it this: talk less, listen more. Okay. And we just, this is born out of years of experience in the courtroom and more recent experiences as we're going back, into in-person court more. And I think, this is a refresher. We've talked about these things before, but we want to emphasize on, a few major points that we think would really help you have a more successful court date. Okay. The first thing I want to start with is when you're asked a question by the judge, or maybe even your lawyer on the spot at that moment, keep your answers short.
And yeah, that's as simple as that. And I think a lot of the times is people have, like, they think that context is important. Sometimes it is, but there's a basis to when it's required. The reason why we're suggesting it is because you might hurt your position with the more that you say. And it happens often. There's a reason
I would
why.
say 99% of the times people speak beyond 30 seconds. They're saying things that are hurting their case.
Absolutely. And like a lot of the time you don't recognize, because obviously you wouldn't do it. I would
Yeah.
imagine you wouldn't do it if you didn't. But the reality is, there are a lot of things that, clients can't pick up on, but we as lawyers are trained to understand and phrase and put together. So there's a strategy behind ensuring that you say only the question that is asked and be direct about it. You don't have to go into a whole-winded, scenario about why it's wrong. And then again, it leads to confusion. It leads to problems where, again, your position is an issue. And if you're an open court saying something, and then, in your material saying something else, like, it's starting to look a little counterproductive, of course, and credibility would then be an issue.
Yeah, and I think, I mean, I just got back from court today, and I had a very interesting experience where my client would not stop talking. We was asked one question and he just wouldn't stop. And not only, I think the takeaway, the sad thing for me with that was not just that he hurt his case, and I kept saying, stop, and he wouldn't stop. And even the judge was surprised that he kept going. And I actually physically had to touch my client. I said, stop. He's like, no, let me clarify. And I knew exactly the legal opinion that was being formed by the judge. I did not want my client to go down that route. That was not a path I wanted to take my client, because it would not make, his case successful. But besides all of that, the sad part of it was when we walked out of the courtroom and we were having a debrief, the understanding of the court was totally different from what he was trying to say. And interestingly, and why this was a good and a good example of why a person should talk less. And I said, well, now you know. So in the context of emotion, or if your matter does go to trial, you keep your answers as short as possible. If I need more of an explanation, I would ask, and the judges would do the same. And when they ask for an explanation, only give enough for what you've been asked in the next step, and let them keep probing. Don't just go spitting out everything. But I felt really bad for my client, because I had another lawyer with me in court that I asked, from our firm, and I said, what was your understanding? Everyone, the judge, based on her comments and what she endorsed, myself, the other associate in the room, the opposing counsel, everybody in that room understood a different thing from the point my client was actually trying to make. And that made me realize how important it is to say less, because he thought he was making X point, and he went on a tangent about it, but we all understood why. And so maybe if you had stopped, there's a way that evidence gets to be presented. If you're asked questions and you just give them much, allow your lawyer, if you have one, to control, how the evidence is being presented. And if you don't have a lawyer, then, maybe just, if you're self-represented, just don't go off on a tangent. Just give whatever is, necessary.
Yeah,
And yeah,
and
go ahead.
absolutely.
No, go ahead.
clients are not necessarily asked to speak. I've noticed more of the time if, the court deems there to be an explanation or a specific comment that they'll ask, they're usually very direct questions. They're not, what is the history behind, your they're not complex questions. They understand that people have lawyers and that wouldn't be appropriate to ask a client without their lawyer kind of just advancing to be able to advance kind of that more convoluted answer, I would imagine. But the reality is they are very simple questions. Stick to the question that's being asked to you. If you ever have doubts about what you're saying, again, you would have had your materials in advance. You would have been able to read them. You would know the position that's being put before you. And if you ever have like a question that you might think that the judge might ask you, canvass it with your lawyer. What an appropriate response would be. We're not going to coach you on what to say necessarily, but it's just making sure that you don't hinder your position, more help it.
Yeah. And I find that if you're not even sure, you're better off not. There's times where parties have not been quick to answer, and I say something like, that's something we would have to think about, or that's something, and the judges, they understand and they're okay with it. And I think a misconception people have is that being in court at every particular stage is an opportunity for the truth to unravel. You have to remember that you're in a conference. So if in the context of a trial, even, we might be able to refocus. We have opportunities to ask you more questions and redirect and all of that. At a conference or maybe a motion, for example, we don't get that opportunity. The judge asks you that question, you go off on a tangent, you say things that are not relevant to that, and we cannot create more context. We could try, but we don't have as much time in the courtroom with that. And frankly, as I said, 99% of the time, it's really not relevant to anything, right? If it's relevant, we would be saying it. And if we're not, maybe start off by hiring a lawyer that you trust, because if you trust them, then maybe you would not feel the need to say it as much. But I joke about that. I do joke about that. I know that most people trust their lawyers, but it's personal to you. It's personal to you. It's your life. It's your, this is the most difficult struggle, probably besides death. And for some people, this even feels worse than death, right? Because almost every day of going through this process, it's difficult. So I recognize that. But that's why I'm sharing this tip with you today, that be very careful in court, in any context, when you're asked a question. Just remember that Angela and Shireen said to you today that less is more. Just keep it short and simple. And if a court wants more from you, they would ask, okay? We didn't keep that short, okay? We know that. We know we went off there.
Less is not more in this scenario.
We just needed to hammer this point as much as possible, that please don't go off on a tangent. Don't go too much don't think, sometimes you might think you know where the judge is going with it, and just don't answer. As Shireen said, they would never ask you such open-ended questions. They're usually asking for very specific information. Give that and stop. Okay, so I'm going to stop. Okay. Another tip we have, and this is just listen to what the judge is saying. People get so focused on what they're going to say that they're not listening to what the judge is saying. And then they keep saying the same thing over and over, and they're not hearing where the judge says, I heard you, I understand what you just said, but I'm not changing my mind. And then they keep going on.
And sometimes it's hard, right? There's a lot of emotions fueled up. You might not necessarily be in a good headspace to completely be open to listening, but try your best to really actively listen. Don't focus on everything else that's happening around you in that scenario. When the judge is speaking and providing, their comments, and when the lawyers are speaking, just listen. Just listen. At the end of the day, you're not going to repeat the conference. The conference is not being recorded. You don't get an opportunity to revisit it. So, kind of what's being said is important. And it also, there's situations where even lawyers, I've noticed, have not listened or gotten the judge wrong because they weren't actively listening. And so it's very crucial that you listen, you understand. You don't have to necessarily agree, but listen. These are still very experienced members of the bench, and they have a lot to offer. Sorry, they have a lot to offer. So their experience, well, whether or not, your lawyer might agree, you might agree, disagree, listen.
Exactly. And especially conferences are so important. And I always tell clients that that's my opportunity to hear how a third party sees my case. Because usually before we get to court, I mean, I've heard my client's positions, the other side. So for most files, we've probably tried negotiating at first. We disagree. And then the other side, whether we or the other side goes to court first, someone goes to court. And then but at that point, we're all married to our positions and we're so stuck on them. And maybe we're just seeing things from a very narrow focus. And the number of times that I get to a conference and I see things from a different lens. And it works twofold. One, it helps me refine my client's positions so that if I wasn't going a certain direction, it might, I can redirect. I can see the weaknesses in my case. I can see the weaknesses in the other party's case. It's really not a time for me. That first off, in a conference, that judge is not going to make a decision one way or the other. So why am I spending all the time convincing them of my client's truth? I would, if it's a legal, if it's information that might change the judge's recommendations, I would insist on putting it out there. But once I've heard, once I listen, then I can know the weaknesses of my case or the strength of my cases. And sometimes, honestly, they throw out things that we never even thought about. And now you can latch onto that and go refine your case, right?
Absolutely.
So,
There's nothing more that I could say on that. That's really covers all of it.
yeah. So I think this is a good time to even talk about not because we need to listen. Can you please try not to distract yourself if you're self-represented? And most especially, do not distract your lawyer.
Yes, this happens all the time. Like I'll see like clients like frantically writing and like creating such a and this is like where the lawyer's actively trying to listen to maybe the recommendations that the judge is making on a specific issue. And for example, it might be the reality is that the judge needs to see a little bit more, needs to see some more evidence supporting this particular juncture or whatever the situation is. But your lawyer might be, distracted by, the physical I guess, I mean, obviously, I'm assuming that this is in-person court.
In person, yes.
Just the frantic writing or the tapping or, and we can understand like you're nervous, but we want to keep the distraction to a minimum. I see it all the time, even just from my clients, from, the other side, and I can see the frantic writing, the verbal, the very nonverbal cues about what should happen, what they want the lawyer to pay attention to while they're also busy trying to pay attention to the conference so that they can better help you.
Mm-hmm. No, I hear like 100%. And what I found that, I mean, if you're frantically taking notes for your records, fantastic. But in most cases, I've had clients make notes to me because they've latched onto an issue that is not as important and the judge is giving recommendations and they want to correct a fact.
Yes.
So an example, say, today, for example, we're arguing the date of cohabitation is an issue. These people have been together for over 30 years. And, the difference between the dates of cohabitation is about a couple of years. So it's either going to be 30 years or 32 years. I had already conceded to the judge that I recognize that those 2-year difference would not make a significant difference when we're calculating spousal support. Absolutely none at all. So even the judge didn't care at that point. She's like 90, whatever the date is, it doesn't matter. Her recommendations were just ongoing. But my client is writing and trying to give me proof of why his date of cohabitation that I agree with him on is the correct one. It's not that I can't see your frantic writing. But it's because we already know that it has no legal ramification.
Exactly.
So I don't know what else we could say to that. So maybe sometimes just trust that, if it's not, and sometimes I would, I'll just maybe tap my client a little bit, or I'll say something on the notepad, like, I know it's okay. But the challenge is that moment I'm taking to write to you, my concentration is divided. So I might be losing something valuable that the judge is saying. And you might think you're telling me something important, but as I said, that little factual error has no bearing on the legal outcome of your case. Now, I know it's important to you because you want the truth to be known and all of that, but in the context of us being in the courtroom, my expectation is that you hired us for a certain outcome, and we want to be focused on getting that outcome for you. Okay, so, but aside from even those distractions, I think Shireen, you mentioned this a little bit earlier, watching for non-verbal cues, and I would say from the judge and especially your lawyers.
Yeah, so like if you accidentally go on a tangent and your lawyer is telling you, in that scenario, like giving you cues to stop.
Maybe tapping you, maybe just tapping you softly, just waving at you softly, like, look, or the judge's face is clearly.
Absolutely. You'll know, like, the reality is, like, well, they're supposed to remain, well, not supposed to remain expressionless. The reality is people have expressions written all over their face. If you're starting to see that the judge is getting very, I wouldn't say not disappointed, but very like confused with what you're saying, that should be a cue. If they start to look very, like they're losing their patience, then you should stop talking. And just say, the reality is, again, all of these can be combined injunction to each other because they're all technically relate to each other to have a very more productive conference. But the reality is, just be very mindful if your lawyer is giving you nonverbal cues, if the judge is giving you nonverbal cues. I wouldn't really necessarily, look at.
Sometimes the judges do give very verbal cues and say, I've heard enough.
Yeah.
But parties feel like, no, they want to explain more.
Yeah, and some judges would want to just be kind and patient, but again, you might be hurting your case, but also pay attention to where, you're starting to lose someone, on a piece, or, it's not really connecting to the judge what you're trying to say. And again, if you have a lawyer, that's what they're there for.
Yeah. So the last point I want to make on this is arguing with the judges after they've made their recommendations.
Yes, and this happens often.
Yes. So I would say, even if you disagree, this is not the point for you to argue with them. If it's emotion, if they've made their decision, they'll just tell you that we've made our decision. I've never seen a judge, I've never seen a scenario where a judge is handing out their decision, and then, you change their mind. Like, obviously, if they're saying, 2004, when it's supposed to be 2002, something like that, they would change. But in general, if they think, you should be paying spousal support and you don't think so, you don't have to argue with them necessarily. And it's so counterproductive in a conference. You've heard the judge's reasons why they think something's appropriate. If you disagree, the job should not be to try to convince the judge with your words at this, event. What you should probably do is go back and gather evidence that would, so that the next time, because most times with conferences, you're attending multiple times. So this is not, and the whole idea again is that by the time you get to trial, your case is well refined, it's narrowed and all of that. So rather than arguing with the judge and insisting that they agree with you, that, support is not payable under any circumstances. If a judge is saying, well, I think there is support to be paid, there is a compensatory element to this, and you vehemently disagree, now your homework is to go home and put together evidence that refutes everything the judge said. Because if the judge finds that there is no basis for, that compensatory element and XYZ, or if you're arguing the length of cohabitation, go put together more evidence that can convince the judge. But you're not going to convince them by word of mouth. And if you're in a scenario where it's a he said, she said type situation, you have to be prepared that the court may accept the other side's version as more credible, in spite of what you think, because they have no evidence to the contrary. So now your job is, do I need to get witnesses? What are their supporting documentation or evidence can I bring to make my point?
Exactly.
Yeah. So anyway, we hope that we have, given you some things to think about. But if all you get out of this is just the title, just know that our tip for you when next you're in court, is just please talk less and listen more. And until next time, it's bye for now.
Bye.